I've had some very thoughtful and some provocative comments this afternoon, and I'd like to open it up to some questions. Charlie, and we've got people coming through with mics, and if you'll just give them a second, they will get to you.
Thanks. Is it on? Can you hear? No? Can you hear? Thank you. Nope. Is it working now?
No, but we
nope.
can hear you.
All right.
He's going to get you going here.
Shout. Okay. This is a question for Bill. First, I want to salute what you and your company are doing in terms of transparency and disclosure. I do want to ask you one question about your comment that to get access, it's necessary to make the political contributions. If you talk with members of Congress and others, many of them will tell you they don't like having to spend all the time they spend raising money. So what would happen? Your company is a very important company. It should be heard. What would happen if you just stopped making those contributions, if you decided not to have the PAC contributions at all? The flip side of the question is, and we've heard this before, there are a lot of interests in the country, early education, for example. A lot of people think it's not a priority because the advocates of early education don't and can't afford to give PAC contributions. So what if you just said no? What would happen?
Well, I think the short answer to your question is this. If we just said no and stopped making political contributions altogether, our ability to have, to use the word I used initially, access to a wide-ranging number of elected officials, however distasteful they find fundraising, would be significantly curtailed. And by access in that sense, I don't necessarily mean you have a fundraiser and you give money and you get a chance to talk to folks then. I think the access is a little bit more subtle than that. The fact is, if you have supported a candidate or you've made contributions and you want to get somebody, you want to get Tony or you want me to get in to see their staff, just human nature, proper or improper, the fact that the contribution has been made is likely to have some influence on the priority that is given to giving you the ability to talk to the elected official, to that person's staff. The other thing I want to say, and it wasn't the question that you asked, but I want to expand on that just a little bit, is that Tony's company and my company right now are on basically opposite sides of an issue relating to the speed with which EPA regulations are going to be implemented, clean air regulations are going to be implemented. Tony's company is more coal concentrated than we are. The arguments are very, very credible, good arguments about jobs and how quickly and reliability and the like. Our company is nuclear and we don't have air emissions. We are both talking to the same people, the people who work for us are talking to the same people. I suspect we're both contributing in some way to the same people, and we're getting access. I think those people are going to make better decisions, whatever the decision be, whether it favors Tony's company or Exelon. They're going to make better decisions because they've given access to people who have views that are going to be able to inform them on industry-related things. So I think if you could, in a theoretical world, take away political contributions from everybody and get the same access and have the same discourse, so public officials, elected officials, could have the same input from the various parties that have it, that's probably, in a theoretical world, a good thing. That theory will never in reality happen. We have to, I think, and we have to certainly with our shareholders, confront the basic reality that human nature and the number of parties who are out there associated who are advocating, this has to be part of our tool to get our story told.
I'll just add one point. The case or the circumstance that Bill talked about, we recently had a fundraiser with a member from Illinois, and it's John Shimkus, and we operate a coal handling facility within his district, and Exelon as a electric provider. Shimkus agrees with AEP on this argument about the retirement of these coal plants. But I was sitting directly next to an Exelon person at this fundraising event. We both contributed the same amount of money. We both had adequate time to make our arguments. We both will go back after the fact and continue to make our arguments. I think at the end of the day, based upon where that member came from, where he went to school, what his philosophy is, has a tremendous amount to do with where he's going to come down on this issue. In regard to your question about education, there is the National Education Association. When you talk about the term special interest, it's special until it's my interest. And I think that's something that you need to keep in mind. The point also that was made about transparency, in many cases, people will argue for you to be transparent, and they will use that against you. And the case that I suggested, where the group did violate a code of conduct and basically gave false information or misrepresented information going into the Congress, a number of outside groups said you should leave because of that. But some of those same groups had similar violations. So, for instance, that was a circumstance where coal entities were lobbied. At the same time, NGOs and environmental groups were going through the controversy of ClimateGate. There were allegations that the studies and science that they were using was false. So you could make the same case to if an environmental group is contributing to a university and that university has allegedly manufactured the science, should they stop contributing to that university, or should they continue to engage with that university but argue for maybe more rigorous standards? So it's more of an art than a science. One of my favorite quotes about politics is like roller skating. You go partly where you want to go and where the damn things take you. And I think that applies to transparency as well.
Dave.
I'm sorry. Could I just?
Go,
I want
please.
to have just 1 minute of rebuttal for Mr. Gottschalk's
You deserve the closing argument.
if that's okay, if I may. It's hard to sit up here and in 8 minutes tell exactly what happened over a 13-year period in this case. But a couple of things that were glossed over in Mr. Gottschalk's discussion is that we had two cases, but the contract case in Virginia was not with Massey Energy. The contract case was with Wellmore Coal Corporation, who Massey Energy had bought and had an indemnification agreement that they had to abide by in representing them. And they made it very clear that they were not a party to this case throughout the whole thing. So there was no connection there other than they were representing Wellmore Coal Corporation. Massey purchased Wellmore Corporation, and we proved this, solely for the rights to a coal supply agreement that they coveted. That coal supply agreement, and this was proven by their own documents, the coal supply agreement was something they were trying to extricate from Wellmore and from Harmon so that they could move it to their high cost or their high margin operations in Boone County, West Virginia, which is where we brought our suit. And Boone County, Massey was the largest employer in Boone County. They employed over 3,500 people. And Harmon, all the companies that sued Massey were all West Virginia-based companies. And then you go back to the fact that I was harmed myself, and I was not harmed in Virginia. I was a West Virginia resident, and I had the right to go and sue in West Virginia. Did they have better punitive damages laws in West Virginia, or more receptive? Yes. But ultimately, punitive damages in this case were fairly insignificant in the amount that was actually awarded.
I should just comment to Mr. Gabriel. No, in complete agreement. I think you obviously had strong claims because you won in Virginia on your contract claims, and I didn't mean to imply anything different in terms of the merits. I was really more reflecting, independent of your case, how business had been approaching West Virginia because of its reputation, which I think was due to the fact that it's had this long elected system. And this is,
right.
It could have been come out either way. It could have been pro-plaintiff or pro-defendant. When you have elections, you tend to have courts set up so that the parties feel the result is predetermined before they ever get there, as you did when you stood before the court that day.
Right. And the other thing that I really couldn't get into today is there's a lot more going on in the West Virginia Supreme Court than I've talked about today and not going to talk about today. So so when we talk about 7 justices voted ultimately against us and only 4-4, well, the majority, for the first time the majority of the justices here that voted in this, Davis and Maynard and Benjamin the first time around, the day they they came up with their decision, they also voted to reverse the way that the next person in line to be the Chief Justice of the Supreme Court, and they appointed Justice Davis to succeed herself and do another term. It's the first time in 27 years that West Virginia had done that. The person that would have been the Chief Justice at that time would have been Justice Starcher, who voted with the minority. So there's never a minority justice ever appointed a judge in our case. It was always someone from the majority.
Let me supplement what our distinguished speaker has said and why this campaign is so important. And that is that these patterns of subtle corruption pervade all the decision making, and it's you scratch my back, I'll scratch yours. And when you look at this Thomas versus King County Chronicle case, you'll see how that not only affected the judging at the Supreme Court, but at the trial court level. It's very hard to say that in a system that is so distorted by this corrupting influence of money, it's very hard to say that there's a simple way to get at this. In the same way, it's very hard to say what is the board's obligation to, if you say a board of directors is obligated to look after the interests of the shareholders, which shareholders are you talking about? Are you talking about the officers who have significant shares and options? Are you talking about the institutions which dominate public holdings in this country and are coming and going constantly? There's no sense of, for the most part, in many of our situations, of any commitment to the long term. Perhaps not even the employee, if they're employee shareholders, who's to say what their commitment is to. So I find it kind of like the word transparency. Who are we really looking after, if not for the system as a whole, to the moral, legal core of the system, which protects this great free enterprise system we give lip service to? And I guess I come down, with all due respect to Tom, to thinking that your speaker here today, Mr. Capron, we were very lucky to have him so he could straighten Gottschall out in this conversation. I'm very concerned about another matter we haven't given enough attention to. You get into a spending war because you have to protect your company's role in this. And so you end up spending money that you wouldn't otherwise spend because you're fussing with some guy that's got endless money, or the owner or the principal shareholder has endless money to throw at these things, because we're all victims of this. Unless you get this lady, just remember Cindy is here at the door writing down names of donors and advocates.
He is my new best friend.
Anyway, what you have here is still a system that to the spender goes the spoils. Stop it.